So here's the bad law. Holding that any questions that do not prolong the stop are valid under Mueller versus Mena. This is just a few of the cases, this isn't all of them. The Ninth Circuit, this case named Mendez, for service denied. 10th Circuit Stewart, Georgia, and Celeron versus State, 2006. And some recent examples, a case from just a week ago, a traffic stop that led to an immediate drug dog sniff, did not extend the stop, therefore was valid. So you got cops that are carrying dogs around with them in the car. Can they do a dog sniff while they radio in, they have somebody check on the computer? And also, just thought of this, a lot of cops these days have their own computer terminals in the car. They can run it themselves. They don't have to go to dispatch. So if they got a computer terminal in the car, they can run it, get the answer back almost immediately. So if they can run it and get it back immediately, what if they do the dog sniff first? They've extended the stop. They've tried to facilitate the use of computers to do the quick check, get it over with, and get the cop back on the road. That's important too. Without having him sit or wait around for 5 minutes while they use an old outdated computer system to run the NCIC check, and whether or not there's wants or warrants, whether or not the driver's license is valid under the state law. The good law, recognizing reality. We all know the reality is that motorists stopped on the side of the road are vulnerable, subject to coercion just by asking questions. And even if the officer says a person is free to leave, as long as the cop is standing there, is the person really free to leave? Because our social conventions are the person is not. They're supposed to stand there and be a good citizen, like you heard Jerry said talk yesterday about that confession is good for the soul and all that bullshit. You're not free to ignore questions from a cop. That's our social convention. If the cop's asking you a question, you're supposed to pay attention to the good officer and at least find out what he's asking. Remember, Terry says in the case law afterward, there's no problem with addressing questions to somebody if the stop is otherwise valid. And I love the infamous Lieutenant Colombo gambit, which has been recognized in plenty of cases over the last 15 years. One more thing, if you don't mind, and you see it a lot in Kansas. Apparently they were trained for this in Kansas, because I remember reading at least a half a dozen cases before State versus Thompson. But it's now recognized as unlawfully continuing to stop. This case is in the materials, I believe, and that case is only about, it's from late 2006, so it's a little over 18 months old. Because, remember, Colombo said, well, my superiors, they need to know one more thing. It's not me, it's somebody else needs to know this. I'm just the carrier of the message. So don't take offense at this, I just have to ask. Where the district court has expressly found that there was no disengagement by the officer between return of the documentation and additional questioning, the undetectability of any transition to a consensual encounter. Remember, I was talking about, I know when I see it, you just can't really tell. The facts in every case could be exactly the same, and courts could look at them differently. Depends on your state and how you argue the case, you'll see. The undetectability of any transition to a consensual encounter weighs heavily against the objective conclusion the driver should believe that he or she was free to go. And that's the question, what does the person objectively believe? Which is why the video can be really important. End the conversation and simply drive away, which is a touchstone of the proper analysis. Continued activation of the emergency lights is a factor to be considered with totality of the circumstances. This is my assessment of the cases. I haven't seen this listed as a laundry list anywhere that I recall. Motorists were stopped with the blue lights and they remained on. Of course, they remain on for a safety purpose. But while they're on for a safety purpose, anybody who's ever seen the videos of a nighttime stop or been pulled over themselves at night, the light is blinding. For a reason, is to disorient the person they pulled over. The cops will admit that. It's in their training. That's why they have all these bright takedown lights. They can't say it was purely for safety. Just look at the video of any stop at night. The officer remains outside the patrol car, standing there talking to you. Says you're free to go, but stands there. Now, any normal person would say, why the hell is he still standing? Can I just drive off? And if you do drive off, what happens then? Is the officer still talking, trying to engage the motorist or passengers? And again, what is our social convention? This is part of the underlying basis of the expectation of privacy. What does society expect? What's reasonable? This is the undercurrent of the entire body of the law of expectation of privacy since 1963. They continue talking with the officer, drive off risking arrest. I've actually asked this, and I hate to do it because it's one of those don't ask a question when you don't know the answer, but sometimes it doesn't hurt to ask anyway. And I've had cops say I would have arrested him. Great, so he wasn't free to go, was he? No, he wasn't. In my mind, he was not free to go. If he drove off, I was going to stop him again, or I'd chase after him and get him for fleeing. They expect, society expects, and the courts expect people to stay put until it's done. Courts expect. So put that back on the court. If the court expects people to stay there, how can you say that he's not free to go? Or they couldn't believe he was free to go? Or whatever. Did the motorist explicitly, the officer explicitly say to the motorist he's free to leave? Does the videotape back it up? Usually they don't say they're free to leave. Sometimes they do. You're free to go, but I need to ask you another question. They're free to go, but is not free to go. Look for them. They'll say it that way. And remember, the burden of proof is always on the government, holding to that burden of proof. So a lot of courts, and within the last 3 or 4 weeks, I recall at least 3 or 4 courts holding that the stop became invalid because the officer just said the wrong words and extended the stop. Therefore, to me, key is getting the court to accept these realities as a part of normal police-citizen contact. And to say that the motorist is free to go and the cop is standing there is pure fiction. And some courts will agree with that.